Hi there, Attorney Andrew Bethel. Let's talk trustee vacancy. What happens when there's no trustee available to manage a trust? This situation, while uncommon, can create legal complications. But don't worry, we'll dive into what you need to know to keep your trust in good standing. And if you're new here, don't forget to like, subscribe, and share the video with that warrior in your family. Drop any questions you have in the comments below, and let's dive in. Let's start with the basics. A trust requires a trustee. If there's no trustee, it's not a valid trust. In California, as in many states, a trust isn't legally recognized unless there's someone in place to act as the trustee and carry out its terms. This role isn't just a title, it's an essential position that ensures the trust functions as intended, from managing assets to distributing funds. It's an office. So how does a trustee vacancy happen? Here's a few common scenarios. First is resignation. Sometimes a trustee may step down if they're no longer able to serve or just don't want to. However, if a trustee resigns, they're still liable for the actions that occur during the transition period in between their resignation and the new trustee stepping in. Next, death or incapacity. Life happens and a trustee might pass away or become incapacitated. And finally, removal. In cases where a trustee isn't fulfilling their duties, a court may remove them. In rare cases, the trust itself may provide a process by which a trustee may be removed without court involvement. Remember that in either case, that trustee being removed is still on the hook until a new trustee can take over. If your trust document doesn't have a named successor trustee or a clear process for appointing a new one, you could be left with an empty position. And that's where things get a little tricky. California has a solution here. Thanks to California Probate Code Section 15660, if the trust is left without a trustee, California law provides a structured process to appoint a new one, making sure the trust can continue operations smoothly. Here's how it works. Trust instructions first. If the trust document itself has a specific process or names someone to fill the role, those directions take priority. So always look to the trust language first. Next, beneficiary agreement. If the trust lacks instructions, the adult beneficiaries can come to an agreement on a successor. This might involve selecting a trusted financial advisor or family member if one isn't already designated. Or third, court appointment. If neither of these options fills the vacancy, any interested party can petition the court to be appointed as a trustee. The court will consider any nominations from beneficiaries 14 years or older and ultimately select someone it deems fit to serve. An interested party just means that it should be someone that is somehow related to the matter at hand rather than just some random person. Typically, this would be a family member, guardian, or conservator, or some other professional familiar with the case, like an attorney, accountant, or financial planner. Yes, this can also be a beneficiary of the trust itself. There are pros and cons to having a beneficiary as a trustee, but I'll link to a recent video I did on whether or not you should have a beneficiary also serve as the trustee of your trust. This system helps ensure the trust's terms can still be carried out, protecting the interests of the beneficiaries. In the trusts that we draft here at Bethel Law, we include specific language to address potential trustee vacancies. Let me share a quick example from our trust documents. If all designated trustees are unable to serve, here's the process we follow. First, current trustee recommendation. If there's a current trustee who is retiring but not being removed, they may select a replacement. The key here is being someone who is not being kicked out. Next, beneficiary agreement. If that option doesn't work, all named beneficiaries must agree on a successor. This would be a simple majority vote of the adult beneficiaries. Sometimes this is limited to income beneficiaries, excluding contingent beneficiaries and those who may not yet be entitled to receive anything from the trust. And third, court appointment. If there's no consensus, the court will step in and appoint a trustee. As discussed before, they should be related to the matter in some capacity. We also suggest that trustees possess some balance of experience in fields like finance, real estate, or tax matters, but it isn't a strict requirement. The only one being that they have to at least be 18 years old. While California's probate code provides a structured fallback, it's best to think ahead, choosing a qualified and trustworthy individual or even a professional trustee that ensures your estate is managed effectively with minimal court involvement. After all, a strong trustee setup helps avoid potential conflicts among beneficiaries and keeps your family's plans intact. Remember, a trust is only as effective as the people overseeing it. Without a trustee, your trust simply doesn't hold up. So it's essential to review your trust periodically, confirm your trustee appointments, and have a backup plan for any unexpected vacancies. However, this is where I pass things off to you. Do you know whether your trust has a way to fill a trustee vacancy? Have you ever been in a fight to see who will be the trustee of a trust? Let me know in the comments below. Thank you for watching. If you found this helpful, please like, subscribe, and share the video. And as always, leave any topics you want me to cover in the comments below. I'm attorney Andrew Bethel, and I'll see you at our next meeting.